Good day, my name is Wouter Kurpershoek and I'm your host for this coming hour. This webinar, we will be looking back at the expropriation of SNS Bank and more importantly, why is it still relevant today? It was kind of a unique case. So we'll be taking a full hour to discuss all the implications and all the lessons learned. Myself, I'm the host, as I said, and I have two guests on my right side. And I welcome her is Professor Ianika Tzankova. You are a professor at Tilburg Law School, but also a partner at Birkway, lawyers. I will get into your CV a little bit more later because you had some type of involvement when it comes to the SNS case, which is interesting and maybe it gives us a little more insight. And next to you is Gerjanne Tzankova. You are a partner in JonesDay in Amsterdam, very international, very large. My first question to you is obvious. Why are we still talking about the SNS case?
That's a very good question. We had a decision after 8 years at last about the compensation that was awarded some 2 months ago.
For shareholders?
Yes, but most importantly, not everybody may be aware that the current this Intervention Act might be still even more relevant, or still relevant in the current pandemic, because it can be applied also on certain insurance companies, and we all know they are under big pressure right now.
Gerjanne,
Yes.
for you as well, you are dealing and wheeling in your daily life.
Dealing and wheeling.
What makes it relevant for you?
Well, I was involved in the case, of course. We
Yes.
represented a group of bondholders who were expropriated because you, Wouter, you mentioned shareholders. But I think one of the extraordinary things about this case is that not only shareholders but also some type of creditors were expropriated, which were the subordinated creditors, so mostly bondholders. And so we represented them in this case.
Yes.
Okay, before we go into your personal involvement and to hear some stories maybe, let's get back in the atmosphere when it actually happened. We have 2 video fragments. The first one is of our finance minister,
At that time, yes.
at that time, who is announcing actually, well, the new ownership pretty much of the government when it comes to SNS Bank. Let's watch this video fragment.
Vandaag, vrijdag 1 februari 2013, is SNS Reaal volledig in handen gekomen van de Nederlandse staat. Ik heb SNS Reaal op basis van de Interventiewet genationaliseerd, in overeenstemming met de minister-president en in nauw overleg met de Nederlandse bank, zoals de wet bepaalt.
Gerjanne, can you still remember this?
Yes, I can definitely remember this. And I also know that it was a very firm decision by the minister by that time.
Unprecedented even?
It was unprecedented because it was the first time that the Intervention Act was actually applied. So in short, what happened, it turned out already for a couple of months that there was a significant capital deficit at SNS Reaal, the group.
Yeah.
And that was in particular due to one of the subsidiaries called Property Finance, which was actually the real estate portfolio of SNS Reaal. And well, it had been discovered that the properties were largely overvalued, and so that in fact the capital was much less than according to the books. So they had to take a write-down, and so the result was that they did no longer comply with the Basel III rules, and had a big problem. Technically, the bank, or SNS Reaal, was in fact bankrupt. So what happened then is that the Dutch central bank threatened to interfere by applying the emergency regulation. Well, what the emergency regulation, I don't know, everybody is aware of that, but it's a special tool that the central bank has to intervene. But in practice, applying the emergency regulation, in fact, means that the bank will go bankrupt. Why is that? Because they will no longer have an entrance in the banking system, so they will not be able to pay anymore. So that was the threat on the table. The central bank said, okay, SNS, you will have to solve your problem within very short period. I think they got 3 weeks or so, and if not, then I will apply the emergency regime.
Yeah.
And so the minister knew if that's going to happen, the bank will collapse and go bankrupt. And then, of course, there was the issue of it's a systemic bank, so very important for the financial system within the Netherlands. And so some people call it too big to fail.
Yeah.
You have to save it because otherwise the complete financial system may collapse in the Netherlands. And so then there suddenly was this beautiful act. It wasn't a coincidence.
All of a sudden.
Yes, all of a sudden it wasn't a coincidence because the act had come about very swiftly
Yes.
when the problems at SNS Bank started. So it was basically drafted or specifically
tailor-made for this case.
Tailor-made for this case, yes. And
Okay.
may I just add one thing? One also should keep in mind that we had a few years earlier in 2008, we had the nationalization all of a sudden of Fortis Bank.
Yeah.
And that cost a lot of money, let's put it that way. And the experiences were a bit doubtful in the sense that the second time there should be special provisions, special instruments. So Fortis could not have happened again, and that's why this law came about.
Okay, before we get into the story a little bit further, you brought a second video fragment. What are we going to look at?
The second one is the hearing at the Council of State, and that is the first stage of the appeal proceedings against the decision to expropriate the bank.
Okay, let's
maybe to again explain what the extraordinary factor in the case was, that not only the shareholders were expropriated, because if you think about expropriation, you think about taking away ownership, so you think about the shareholders.
Yes.
And assets,
and
indeed.
I think everybody's surprised, in particular our clients' surprise, so the bondholders' surprise, they also expropriated the subordinated creditors. And that, I think, caused
a lot of commotion.
Well, you see a little bit of the excitement and you can feel the atmosphere in the air. Let's watch the video.
Van harte welkom allemaal bij deze zitting van de Raad van State. Over de SNS-onteigeningsbesluit. Een zeer grote drukte, maar van harte welkom.
Vanmorgen bij de Raad van State. De VEB klaagt namens meer dan 5000 leden de minister aan. Samen met nog vele duizenden andere gedupeerden. Een processie van juristen trekt de grootste zaal van de Raad van State binnen. Honderden advocaten stellen dat de minister het recht niet heeft de SNS-bank te nationaliseren en alle bezittingen te onteigenen.
We even saw you in the picture.
Yes, it was a long time ago. I have a different haircut.
But what was your involvement?
Well, obviously we cannot disclose confidential information, but I was representing clients, bondholders, who had suffered damages as a result of the expropriation.
Was here still some type of disbelief almost?
It was, as Gerjanne said, it was just a total surprise, taken by surprise. It wasn't just assets, but also debts, distressed debts that were expropriated. I remember actually vividly, I think this is one of these legal historical moments. I was driving in my car on my way to the office on the 1st of February, and when this happened, and nobody knew exactly what the proceedings were going to be. The time periods were very short. The legal protection in this particular case took place in 2 stages. First, the hearing at which you saw the footage from the Council of State had very short time periods. If you have a look at the timeline.
Yes, we have the timeline here.
Yes,
of the initial court proceedings.
It happened really within a heartbeat. And I remember I got this phone call whether I was able to assist the clients, and I was surprised at the beginning that I'm not an administrative court lawyer, because the first stage of the proceedings are before the highest administrative court. I said, I'm not an administrative lawyer, I'm not an expropriation lawyer. But it was so complex. You had lawyers at this hearing that you saw from all different backgrounds and expertise. You had financial regulation, competition, expropriation, securities, bankruptcy, and you really needed all these expertises because nobody knew exactly what this was all about. You had very short pleading time to present your argument, so you had to be very selective on what you're going to tell. Did you pick the right arguments? You could see the justices of the Council of State didn't know really what was happening either. They were not used to this type of proceedings.
Well, wasn't the reality back then that we had a government that analyzed the situation and realized, not on our watch, we will have this bank collapse and we will have a systemic crisis, and this is what we're going to do, whatever the consequences.
Yes, but of course it interferes in people's property rights.
Obviously.
And of course you need to have legal protection also, even though the government believes this is the right thing to do. It has to be tested in front of a court.
But
and
we
so
didn't
the
have, I'm just trying to be the advocate's devil.
Yes,
I mean, the government didn't have time to really sit down and let's,
Well, I don't know.
discuss.
Well, I think they did have time to prepare this act, this law, to enact it. As I said, the time period, the timeline for filing appeal were very short. One should also keep in mind that the grounds for appeal are being tested only on a very marginal level by the court, which gives a big discretionary power to the minister to take such measures, and with hardly any proper opportunity for review, although maybe we're a bit biased.
The case went. In this case, went to the European Court as well, and the European Court ruled a little bit strange ruling that that there was due process, a fair trial.
Yes.
Even though it was within such a short time limit.
Very short time period,
basically only, you could say the whole thing happened in 2 weeks.
Yeah.
But the reasoning was, I have not seen that you could develop any more arguments if you had more time. Which is,
say again, you could not?
Because the test that the European Court did was asking the question, would you have been able to develop more relevant arguments
if you
had more time
to prepare
than this time window, which was so
But it was a combination of short time period in combination with papers, documents that were really redacted by the state. So even if you would have more time, but if you didn't have the proper documents or only redacted documents, it would still have been
I read somewhere
difficult.
that the reality was that we had a traumatized government who was not going to relive all kinds of successful or rather unsuccessful interventions from the past. So they came in with force and they decided to deal with the consequences later, pretty much.
Yeah, that is what happened. And in such cases, that's why you have rule of law and...
Yeah, although of course there definitely is in a way a sound legal basis for the expropriation, because there is this act, the Intervention Act, that has gone through Parliament. So yes, they gave themselves a very useful tool and with a legal basis. So I would not say that by definition the Intervention Act
is evil.
Or violates
by nature
certain human rights or something. I don't think that would be fair to say. The question only is, if you only have such a limited time window to appeal, and because there has to be the possibility of a serious testing afterwards by the courts, in this case the Council of State, and that is, I think, and Ianika
I think
has the experience, is you might doubt whether that is
that's entirely the case. And if I have to be very blunt, I simply think it's very hard to overturn such a decision in the first stage. I think it's something. It's a ritual dance that you do. But it's
but you
basically
guys didn't have
very
any strategy?
hard.
I mean, was there any strategy from the sides of the people that, you know,
it was
were shocked or
for
was
the
it
expropriated?
Yeah.
Well, the strategy was go there and try with all the lawyers, because you saw how crowded it was. It was really unprecedented, and everybody tried in a very limited time period. You had to prepare with your clients. So this very new piece of legislation, facts not completely known, to come up with the best that you can. Having said that, though, one should also keep in mind that at that time we didn't have any European legislation in place. It was only the Intervention Act.
It was a national...
It was a national law. So now we have some European instruments. Maybe next time, if something similar will happen again, we might have some extra grounds based to bring forward based on that European legislation. But if that's not the case...
And you could doubt that, because indeed, put it in a European perspective, we now have the European Bank Recovery and Resolution Directive, the BRRD, I have to say it.
We're mixing up.
Correct. And this is also an instrument that's aimed at preventing financial institutions, banks in this case, from collapsing, from going bankrupt. And they have some authorities to intervene as well. There is a so-called single resolution board. It's a board, I believe it consists of people from the European Bank, European Committee, and national central banks. And they can also take measures like an expropriation, or at least to force the sale of a bank against almost zero. And so this directive also contains certain compensation mechanism. I assume we'll get to that, but
at
I
that time
think
that
this
wasn't
will
the case,
the question is if the authority that this single resolution board has might even go further.
Okay, my suggestion is to go a little bit back and forth. So go back to the history, the lessons learned from then, the examples from then to the realities now. First, also for our viewers, why is it relevant literally today? What can happen? With whom? What kind of institutions? What? What is the SNS bank now?
The current SNS... Well,
this is systemic.
You had about insurance companies?
Yes, insurance companies, but it have to be systemic. That's the thing, right? That's the criterion. It has to be systemic, which means institutions, financial institutions that are really very important for the economy and for the stability.
Yeah, we might of course also be closely before a new crisis. We don't know, but what this pandemic
After
will
the
result
government aid
in.
will stop, what will happen then?
Exactly.
How strong are institutions?
And is there means to expropriate? That's the other
direct question then.
Yeah.
Do you feel that if we get another systemic organization or institution or a crisis comparable to for the SNS case, are we then ready to deal with that? One, from the side of the institutions that are in trouble, but also on the other end, the government? Or is there nothing that changed? You mentioned already some European changes, some boards.
Well,
are we facing the same type of questions again then?
Partly, I would say partly similar, partly new.
Well, I think, of course, what is the cause, mostly the cause of the problems within the financial institutions are the capital requirements. That is, it's something that's hardly ever discussed, but usually we are talking about companies, institutions, which in itself are financially healthy because they don't make loss. But because of the huge capital requirements under Solvency II for the insurance companies and Basel III for banks, that's often the reason why they get into trouble, because they don't reach those requirements any longer. And so the same applies to SNS Bank, but we even saw it with DSB Bank. DSB Bank was actually bankrupted because they didn't meet the capital requirements. But at the end of the day, after the bankruptcy was wound up, all the creditors were fully repaid.
Yeah.
Which means...
Because there was money.
Yes. But if you ask, are the problems solved? Well, we're going to see it now, because why do we have these capital requirements? We have them because we want these financial institutions to have the buffers.
We don't want to get into trouble.
In case of a crisis, that they can use their reserves, like the Dutch state it basically is doing the same. So it will primarily depend on the capital situation of those institutions.
But are you worried that these requirements are too strict, are too harsh, are too unrealistic?
I have thought it. I've also represented an investor in an insurance company where there were the same type of questions about the capital requirements. And I thought, in itself, these institutions are healthy and profitable. So why threaten to push a bank like SNS over the cliff, not because it's loss-making, but because the capital, their buffer, their reserves are not sufficient. So I have to, but I'm of course not a financial expert. I realize
SNS,
that.
there was the issue indeed with the real estate.
Yes, but that's why they had to write down on their capital, and that's why they went below the levels. But so I'm not an expert. I think it's not something we can...
If we look at the Dutch Intervention Act then and now, did anything change?
Well,
any add-ons?
As I mentioned, we mentioned, we do have this extra European layer of European. It's the European jurisdiction of the European institutions that it can step in if the bank concerned meets certain criteria. It's very important for the European for the stability of the European single market. So that is the criterion for the European institutions to intervene, and if we deal with financial institutions that is very important for a national market. We might see this competition between the national authorities and the European over having the powers to intervene in the situation. So that is new, I think. I think that is a very new situation.
I think you're right, Ianika. I think you may even ask the question whether the Intervention Act will ever be used again.
Yeah,
because of this European tool that is now available. And given the experience that we have, but then we go into the discussion of the compensation, of course, which comes after the decision.
I think the question will be, is this financial institution, is it too big to fail for the national market or too big to fail for the European market? And you may answer that question differently, depending on...
And also when you look at the role of the courts, back then and back now, will that be different when we get into the same type of situation? Will the questions be different? Or will it all be the same?
I think basically the procedures that you go through, like first the
Council
appeal
of State.
against Council of State and then the compensation.
The authorities that they have and the possibilities that they have and the way that they will be answering the questions that...
In principle, that hasn't changed, of course.
We have
act hasn't
some
changed.
extra answers.
Yeah, we have
some
learned,
of
course, from the Supreme Court, but then we are talking about the compensation proceedings.
Okay.
That comes after the decision to expropriate. Then it has to be determined whether and to what extent the expropriated parties will be compensated.
Why did it take so long?
Well,
because
that was the proceedings that took so long.
But I know in other countries it needs to be taken care of within 12 months, for example.
No, that's a different thing. That's a different thing. I think, but it's indeed a contradiction that if you want to appeal against the expropriation itself and you try to undo it, then it all has to be dealt with within 3 weeks.
Yes.
Very quickly, yeah.
Then you have an entitlement to a fair and basically prompt compensation, as you always have in expropriation cases. And it took 8 years to determine the compensation. Now, what you were talking about that's the mechanism of the compensation. Maybe I should say something about what are the rules for determining that compensation. You have to have the norm is, the criterion is that you have to have be compensated the fair value of the security, so the bonds in this case, immediately prior to the expropriation. So you have to determine what was the value of these bonds on the 31st of January 2013. So immediately prior to the decision to expropriate. And so that was something that needed to be filled in, to be assessed first. So then the system is, the minister will have to make an assessment first and has to make an offer to the expropriated parties. And that offer must be submitted to the Enterprise Chamber of the Amsterdam Court of Appeal, which is this special court that we have in the Netherlands. It's also called Companies Court for corporate matters. And so in the Intervention Act, the authority jurisdiction is being given to this court to decide on that compensation. And the offer by the minister in SNS case was 0. And why was it 0? Because it was based on the assumption that, what I explained before, that if there had been no expropriations, because that's what you have to do. You have to do the test. What would have happened if there had not been an expropriation? And what would an investor still offer for this security, for these shares or these bonds, given these facts? And so the minister said, okay, it's clear that it would have gone bankrupt because the central bank had announced that it would apply the emergency regime. And if you apply the emergency regime, then you know it's over. So then you would have a bankruptcy situation, and what would a trustee in bankruptcy do? They said, well, they would sell the business.
And nobody won. Huh?
And they would do it in a so-called fire sale, which means they would sell the bank in its entirety as soon as possible. They would sell the insurance company as soon as possible. And given the capital deficit and the fact that these companies were technically bankrupt because of these capital requirements, nobody would offer more than €1.
Yeah.
So they said, or €0 actually, because the minister didn't even offer that €1. He offered
well,
0.
It was divided among a lot of parties.
So the test was done. That was the first step of the test, what would happen in a bankruptcy situation. And so, of course, the expropriated parties had a right to raise a defense against this offer. It's basically a defense to respond to it. And all these same parties that you saw on the little movie, they came back, but this time
for the enterprise
they
chamber.
went to the enterprise chamber by saying this offer of 0 is unfair, it's unjust, the securities were worth more than that, so you have to come with a better offer. And so then the enterprise chamber had to give a ruling on this. This alone, this first phase alone already took, I think, almost a year, because suddenly there was no such a rush, especially on the minister's end. So we now had ample opportunity to submit all the arguments with exhibits and stuff. And so, but at the end, the enterprise chamber ruled that the offer of 0 was not sufficient, so that the securities indeed still had a certain value on the 31st of January, and so that the 0 offer was not acceptable. And so what happened then? The enterprise chamber decided to appoint 3 financial experts, or actually 2 financial experts and 1 of the most prominent bankruptcy trustees that we have had over the last decades. Mr. Daytrink, he's a very prominent trustee, so he...
liquidator, yeah.
So these 3 were appointed to actually establish or do a valuation of all these securities. So they had to value the shares and they had to value the bonds that were expropriated. But of course, you have to set the parameters for making that assessment. So that's what the enterprise chamber did. They set certain parameters, and in a new ruling, or in that ruling basically, where they also didn't accept the 0 offer. And then that was the first time that the minister appealed in cassation. So the minister went to the Supreme Court because he didn't agree with all the parameters. There were also some of the bondholders who went to the Supreme Court to attack certain of the parameters that were set by the enterprise chamber, and that created what Ianika said that we have now, because the Supreme Court basically then decided what the parameters are. So, for example, what is the reference date? What do you have to test? What does it mean? Fair value immediately prior to the expropriation. What does it mean?
So
what is fair value?
Yes,
so
and we didn't have that before.
No.
It was just an open norm, and parties differed about how they should be interpreted and what is the proper standard to determine the damages, basically, the
Exactly,
value.
yeah.
What about the Council of State procedures?
Well, they couldn't go fast.
They couldn't go.
They were very fast.
That was it.
That was it. Gerjanne mentioned that there were attempts to argue before the European Court of Human Rights that the process before the Council of State wasn't fair, but they didn't
That was
succeed.
the end of that
That
road.
was the end, and it was indeed a funny argument, but at the same time, I think not entirely surprising, because the minister had a very broad discretionary power and quite a wide margin of appreciation. So the Council of State proceedings, I think the outcome wasn't really surprising if you take all of that into consideration.
No, it wasn't surprising. Although they did succeed in one aspect, because what they also expropriated, it's maybe a nice story, the state tried to avoid that they would get all kinds of tort claims because of these actions by, in particular,
shareholders,
the bondholders, but also shareholders. Yeah. So what they did, they said, I now also expropriate your claim, your potential claim against me.
They were quite clever.
They're very opportunistic. Very opportunistic.
And then the Council of State said,
very creative.
Yeah,
You can't do that.
you can't do that.
Very creative lawyers.
Yes.
So what was the most difficult thing to explain to your clients? If you had to explain this very complicated judicial reality here in
We might
in
give
our
different
country.
answers. I think my answer would be what most different, maybe one of the difficult things.
Except for the fact that they were upset.
Exactly, yes, obviously. No, I think one of the points was that it was not just assets, but also debts, like the scope of the expropriation. Secondly, I think, especially for the foreign investors who are used to, in this type of state investor dispute, because you could view this as a state investor disputes, and typically when countries have special treaty in case of this type of disputes, parties could choose to go to international arbitration institutes.
And that couldn't be done in this
and they
particular
didn't,
case.
well, that is the question, whether it can, of course, the minister said, no, you couldn't, because that is the intervention law, and we enacted it, and we said that this is the way to do it, Council of State.
Can't go to a
but that is very, very, that was a big, another...
I think that was a shock.
That was a shock, yeah.
Another thing they clearly complained about is that they saw this as a political
decision.
Trial, actually. That
against the bank.
The attitude of the minister, they were really annoyed by it.
Really upset,
because they found him arrogant, or they found him...
Well, actually, he did say in Parliament, we don't have that movie, maybe we should have done that too, but he said in Parliament, I will take care that none of these capitalists, investors, will be paid a penny from our tax money. And so even before the compensation proceedings had actually started, he had said that. So that was something they were obviously frustrated and annoyed about. But on the other hand, it's also a little bit a typical attitude, of course, from especially foreign investors who will say, oh, look, what is this? What type of a legal system do you have?
Third world country.
Third world country.
Yeah.
So there were a lot of emotions involved.
But they strongly believed especially I think because of what happened at the Council of State, that it was politically driven.
Yeah.
But we have another outcome, so I think, but I felt
8 years later
throughout.
Yeah. Yes, but 8 years
But
later.
8 years later.
And still not over in a sense, because the claim administration process still needs to take place. It could take easily a few
Yeah.
But then help me
more
out.
years.
Was the situation that you, as the lawyers, you know, in a more general sense, that you had to regroup all the time and think, oh, what happened now? You know, what is this?
Yes,
what is our
definitely.
strategy now? Was it like a chess game almost, or was it a game without any rules from your perspective?
Well, I think there were rules. It's just they were not always very clear.
Everything was new.
But the regrouping, I definitely recognize that. I think that's a good way to put it. There was regrouping every time something happened. You try to figure out what has happened, could it happen, how does it affect my clients, and what can I do about it? And this could change all the time.
No
and no
precedents.
precedents.
Exactly, because I remember we got a series of questions from the clients, indeed, who were mostly aimed at what is going to happen, what can we expect, and when can we expect. And so often we had the same, there's no precedent. We don't know. And I'm convinced that the Enterprise Chamber itself also didn't know.
And there was also, there was very little precedence at European level either.
No, this was the
there
only...
was Northern Rock you had in the UK. That is where we could look from time to time, but it was again different
story. Yes.
Different story.
So that is interesting, I think, to maybe zoom into the compensation.
I was going to say, we only have 20 minutes left, so let's get into the road of compensation.
Well, we're almost at the end.
So that was a more successful road in the end, no?
Yes.
Okay. So,
well, that is, it became...
Well, some money came, 800 million or something?
Well, it started to become successful after the experts had been appointed, and they took a total different route than approach the experts, the three experts. So
what do you mean by a different approach or different?
Well, the zero offer approach of the minister was based, as I said, on the assumption that if SNS would have gone bankrupt,
what would have been?
There would have been a fire sale.
Yes.
The experts, they first had to determine what they call the future perspective. So they first had to determine would it have inevitably ended in a bankruptcy. Mm-hmm. Well, what the experts did, they even they described actually two scenarios. They made a calculation on of the value in two possible scenarios. So they considered it also possible that a private sale of the entire bank, or the bank and insurance company, to a private party could have succeeded had the minister taken a different attitude. Well, that was actually wiped from the table by the Enterprise Chamber. So that's maybe the first lesson we can learn, that in a case like this, the assumption will probably always be, if there had been no expropriation, then there would have been a bankruptcy. But then the expert says, look at DSB Bank. Well, that's not what they said, but that's what they actually applied. Because what happened with DSB Bank, who had gone bankrupt, I believe, 2008 or something. So that was sort of in the middle of the rundown of that bankruptcy. And what had these trustees done? They said, well, in a bankruptcy situation, I don't have to pay any debts, right? That's the consequence of bankruptcy.
That's how it goes, yes.
Yeah.
But I can still collect my claims. So what I do, we keep the bank open, and we continue to collect all these mortgage interest payments because that is the largest part of the bank.
Yeah, the portfolio. Yeah.
And so if I continue to collect it, then at the end of the day, I have a huge amount to distribute among the creditors, because that's the duty of a trustee, is to make sure that you collect as much as possible from the estate to distribute to the creditors, not the shareholders, the creditors. So the experts in the SNS case said, well, that is of course the most sensible thing to do as a trustee, because in a fire sale, indeed, the valuation will probably be zero.
You lose
in
value.
a situation like this. While if you continue the bank for, in this case, they took a run-off period of 10 years. They said, well, what would we have done? We would have kept the bank open for 10 years. We would have continued to collect under the mortgages. We don't have to pay the debts, other than those created during bankruptcy, of course, but that's a minimal part. And so we make a calculation on the basis of the information that we have, how much money we would collect over that, during that run-off period of 10 years. And then we can see, okay, then we have to pay the creditors. First, of course, you have the ordinary creditors who have not been expropriated, but they would still need to be paid first. And then I see what the balance is, and what I still have then, I can distribute among the expropriated bondholders. So that's the scenario that they went through. And at the end, but it took indeed 8 years to get there, because of all the resistance of the minister, of course, but at the end of the day, the expropriated creditors will receive about approximately 75% of the nominal value of the debt. And why is it not 100? Because the trustee would have been able to, if you take that run-off period, then you would be able to pay the full amount, but it would take 10 years.
It would take longer.
So you have to make a discount to capitalize the amount.
But still, you say, well, it's not all good in the end.
Well, what do you mean not all good?
When I suggested, well, there was money in the end of the...
Yes,
and
well, there is
used
something
to go
interesting in it, because it's not, prompt. You could say after 8 years it's not prompt, and we still need to wait. That was the point also I want to make, because we have this judgment now, but there is a claim administration process that needs to take place, and we know from other not similar expropriation situations like in Fortis, with kind of collective execution of collective settlements, in a way that it takes a while before you say, yes, here is a sum of money, and before everybody has actually gotten it, right? So,
and of course, the minister can still appeal in cassation. They can go back to the Supreme Court. We don't know yet, because they have 3 months.
Move, or will it be?
There will be 3 months, yes.
Scenario.
So the period is still running, so we don't know that yet.
We don't know yet.
But will he stand a chance then, or?
Well, not to overturn the entire decision.
No.
But they may. I think one of the main issues that was still on the table is that property finance consists of about a couple of hundred subsidiaries spread over Europe. And the trustee said we cannot calculate that 10 years run-off scenario for each of those hundreds of subsidiaries all over the world, so we do that on a consolidated basis. And that is something that the minister has objected to from day one, so they may ask the Supreme Court if you can do this calculation, whether it is acceptable to do it on a consolidated basis. But I don't know, that is one of the questions.
It's an open question.
Okay, let's get into the lessons learned. Lesson number one.
Well, lesson number one. Well, lesson number one is that it could happen today as well if insurance companies get into trouble because of the pandemic, I think, and they're serious enough on the market. Number two would be that not just assets, but the scope of the expropriation is really wide. Lesson three would be if you go to the Council of State for the appeal review, the chances that you're successful are slim unless you come up with something clever at EU.
Otherwise, it will be a very short trip.
It's a very short trip. Which is the next one, Gerjanne?
Well, I think a lesson, but that's in particular Dutch lesson, is that I believe this turned out completely different from what the government had anticipated.
What do you mean by that?
Because I don't think it was ever the intention to pay. I mean, I think the government will, if it stays like this in the final ruling, they will have to pay almost €1 billion.
It's a lot of money, yes.
Tax money, and that is a lesson that actually
for the state,
in any event, the state has learned.
Yeah.
And so coming back to this European tool, that's why at some point I said you can ask the question whether they are going to use it again. And because on a European level, there is also a debate about, okay, how do you have to determine this compensation? And in the context of this debate, of course, the Dutch situation is very specific because it is probably the only country or just one of the few countries where you can have a 10 years run-off period in bankruptcy. Yep. Because the bankruptcy will remain open for 10 years. Well, if you look, for example, to Spain, there they have a rule.
That's a very good point.
That a bankruptcy, the maximum period of the rundown of bankruptcy is 1.5 years. So, which means
it's closer
in Spain,
to the fire sales scenario.
In other countries, the trustees are forced to do fire sales because they don't have this possibility.
Long scope of time.
Yes.
So this creates, of course, an inequality between various member states.
But should the investors be worried then now, still?
Now, from that perspective, the Netherlands is an
There's
attractive
no,
country.
There's no new protection for them. There's no protection for domestic investors, foreign investors. There's not.
Well,
nothing you can offer them when they come to you. And ask.
No, and I don't know. I think if you look at SNS, the lesson learned, if you put it in a European perspective, is that the Netherlands is an attractive country, although you may have to wait 8 years for it, but at the end of the day, you get a significant portion.
You still have to
of
wait
your
and see, but
so wait and see.
Assuming that the Supreme Court
and maybe one other thing that is also new that comes to mind, and which is we have the Netherlands Commercial Court since a few years, which is new, which is an English-speaking court in the Netherlands. Strictly speaking, I'm not sure whether jurisdiction would cover expropriation, but I'm just thinking out loud, why not, if the state would agree to that? So that is something I think.
They have to agree first.
They have to agree
to go to this NCC.
Afterwards, but I would be thinking if you are, if you're a country like the Netherlands, you have just introduced and you're making a lot of effort and marketing to promote it, I would say, and something like that happens, why not offer it to the foreign investors?
Is there a point that we've not discussed yet and that we can still touch on in the few last minutes? we've been talking broadly and very detailed.
Technically, yes.
Because my general feeling is that I get from the two of you that this Intervention Act will not be used easily again.
I think it's ironically because, as Gerjanne said, it was introduced to prevent the Fortis experience when the state had to spend a lot of money for the nationalization.
Protection for the taxpayers.
And protection, and now, ironically, the taxpayers
still have to
need
pay
to
$1 billion.
pay.
Although, of course,
euros.
it's significantly less than the 16 billion or something that the state had to pay for ABN AMRO. But I think the government will probably not be completely satisfied with the way it went, and they will probably look at the European instruments, the European tools. But I think Ianika is right. If we're talking about a bank that's only systemic for the Netherlands, but not on a European level, they may not be able to use the European tool.
Yeah.
But indeed, so then if this for now is the only tools they have apart from letting the bank go bankrupt, they might use it again when there is another situation where a bank is in difficulties.
Yes, there will be this choice of the least
but
of two
it's
evils.
my guess they will try to avoid it because it is not resulted in what they
envisioned.
Given some
had
headaches
intended.
as well for the
Yes.
government.
Yeah,
So it looks like a roller coaster ride that's been going on for years and years and years, but the end is there almost. And it's been quite an expensive roller coaster ride from the point of view of the government, if it ends the way it looks like it's ending.
Indeed.
Well, I sure hope that the two of you will not remember a next day, like it was 9/11 almost, when it comes
The
to
1st of
companies'
February
rights.
2030.
The first, you will always forget that. You will never forget that. Okay, ladies, thank you very much for your attendance and your insight information also. It was very useful and very helpful. For you at home, thank you for watching. You can go to the website of the AvdR and look at other webinars and interviews. They all have one thing in common. These are interviews with interesting guests about important issues in the world of the judicial world, I should say. Thank you for watching. My name is AvdR, and I might see you again in another time with another topic on another webinar.